All right, welcome to our deep dive into a really crucial concept from the Indian Contract Act, the capacity to contract. I mean, who can actually make a promise that's legally binding? It sounds pretty simple, right? But the law has some very specific rules to protect vulnerable people and make sure everything is fair. Now, if you're studying for an exam, this topic is an absolute must-know, so let's jump right in.
So, here's our game plan. We're going to start with the basic rules, the foundation of it all. Then we'll spend a good chunk of time on the most detailed category, minors, and all the tricky exceptions that go along with them. After that, we'll talk about what it means to have a sound mind, and we'll wrap up by looking at a few other groups of people who are disqualified from making contracts. It's the perfect way to structure this for your revision.
Okay, first things first. Before we even get into things like offers and acceptance, we have to tackle a much more fundamental question. Are the people actually making the promises legally allowed to do so? This, right here, is the very core of what we call contractual capacity. So, this is really the million-dollar question, isn't it? Not everyone who makes a promise can be legally held to it. The law has a checklist, a set of criteria, to figure out who has the maturity and the mental state to get into an agreement that a court will actually enforce. Think of it like a legal bouncer at the door of a contract. And here's that checklist, straight out of Section 11 of the Indian Contract Act. These are what we call the 3 pillars of capacity. You have to be of the age of majority, you have to be of sound mind when you make the contract, and you can't be disqualified by some other law. You've got to tick all 3 boxes. If you fail even one of these, you're considered incompetent to contract. It's really that black and white. Now, let's get into our first and, honestly, most complex category, minors. In India, a minor is anyone under the age of 18. And when it comes to any contracts they try to make, the law takes a very, very protective stance. It all starts with one absolute rule. You're going to want to remember this term, void ab initio. It's Latin, and it means void from the very beginning. This isn't just a contract that can be canceled later. No, this is an agreement that, in the eyes of the law, never even existed. The whole idea is that the law assumes a minor's brain isn't fully developed for rational decision-making, so they can't be expected to grasp the full weight of a binding promise. The law steps in to protect them, both from themselves and from being taken advantage of. And this principle was really set in stone by this famous case, Morahabibi versus Dharmodas Ghosh. So picture this. A minor, Dharmodas Ghosh, mortgages his property to a moneylender for a pretty big loan. He gets some cash up front. Later, the minor sues to cancel the mortgage. And you know what? The court agreed with him. They said the agreement was totally void. Not only could the moneylender not enforce the mortgage, he couldn't even get the advance money back. This case made it crystal clear. The rule is absolute.
So, the main rule is simple, right? A minor's agreement is void. But, as with pretty much all of law, the devil is in the details. Or in this case, the exceptions. For any exam, knowing these nuances is what's going to set your answer apart. So let's dig into the special rules that kind of branch off from this main idea.
Okay, this slide shows 2 super important consequences. First, no estoppel. Estoppel is a legal rule that usually stops you from going back on your word, but it doesn't apply to minors. So even if a minor lies about their age to get a loan, they can still turn around later and say, hey, I'm a minor, and the contract is still void. The law's need to protect the minor is more important. Second, no ratification. Ratification is like giving a thumbs up to something after the fact. A minor can't turn 18 and say, okay, that contract I made when I was 17, I approve it now. Why not? Because you can't breathe life into something that was legally dead on arrival. You have to make a whole new contract. This brings up a really good question. Say a minor gets some money or property through one of these void agreements. Can a court make them give it back? This is what we call the doctrine of restitution, basically restoring something to its rightful owner. So what does fairness say here? And the law walks a very fine line. The general rule is no restitution. Forcing a minor to pay back money is kind of like enforcing the void contract through the back door. But there's a huge exception. If the minor flat out lied about their age, if there was fraud, and if they still have the specific thing they received, a court may order them to give it back. A judge famously said a minor can have no privilege to cheat man. But notice how specific that is. It has to be the exact property, and it has to be traceable. If they spent the cash, it's gone. You can't get it back. Now, it's not all one-sided. The law isn't trying to make life impossible for minors. It's just trying to protect them.
So any contract that is clearly for the minor's benefit, where they don't have to do anything in return, is totally valid, and the minor can enforce it. For example, if a minor is promised a gift, they can sue for it. Contracts for apprenticeships are also treated differently, and, most importantly, so are contracts for something called necessaries. This right here, from Section 68, is a game changer. It's all about necessitaries. If you supply a minor with stuff they actually need, the law says you deserve to be paid back. But, and this is a really important detail, look at the wording, reimbursed from the property of such incapable person. The minor is not personally liable. You can't sue the minor and force them to pay. You can only make a claim against their property or their estate, assuming they have one. So what counts as a necessary? Well, it's not just about survival. Of course, it includes the basics like food, clothing, and a roof over their head, but it can also include things like education, medical care, or even legal fees. But here's the kicker. It's all relative to the minor's social status or their condition in life. There was a famous case where a student was supplied with a bunch of fancy waistcoats. The court said those were not necessaries because he already had plenty of clothes. So something isn't a necessary if the minor is already well-stocked. All right, let's switch gears. We're done with age for now. Let's move on to the second pillar of capacity, a person's state of mind. The law is very clear on this. For a contract to be valid, both parties have to be able to understand what they're getting into and what the results might be. Section 12 gives us the legal definition, and it's basically a two-part test. Number 1, can you understand the deal? And number 2, can you make a rational judgment about how it's going to affect you? But the most important part of this whole definition is the phrase, at the time of making a contract. That specific moment in time is everything. You see, the law gets that unsoundness can look different for different people. Some conditions are permanent, but others come and go. This is where the idea of a lucid interval comes in. If a person has periods where they are totally sound of mind, a contract they make during one of those periods is perfectly fine. But one they make when they're not lucid, void. The exact same logic applies to being drunk. If you're so intoxicated that you can't think straight, any contract you sign is void. It all boils down to your mental state at that exact moment of agreement. And finally, our third and last pillar. So, besides age and mental state, sometimes the law just steps in for public policy reasons and says, nope, this group of people can't make contracts. Let's do a quick rundown of who's on this list. We've got alien enemies, citizens of a country India is at war with for obvious national security reasons. You have foreign sovereigns and ambassadors who have diplomatic immunity. They can sue you, but you can't sue them easily. Convicts, while in jail, have a lot of their civil rights suspended, including making contracts. Insolvents, who haven't settled their debts, are limited to protect the people they owe money to. And finally, corporations. A company can only make contracts related to what it was set up to do. Anything outside that scope is void. So, as we pull this all together, what's the big idea? What's the common thread through all these rules? Well, the entire legal framework for contractual capacity really comes down to one single thing: protection. It's all about protecting people who can't protect themselves and making sure that the agreements we enforce as a society are made by people who can truly understand and consent to them. And that leaves us with one final thought. The law builds this shield to protect the vulnerable. But is it possible for that shield to sometimes be used as a sword? A way for someone to knowingly take a benefit and then hide behind their legal status to get out of a fair deal? It's a tricky question, and as we saw with things like restitution, it's a delicate balance the law is always trying to strike. Thanks for tuning in to this explainer.